Thank you, everyone. Do have a seat. Mrs. Brown, as I've indicated, that we will continue with you. You're still sworn to tell the truth. Try and crystallize your remarks. We will go on for an hour. And if you have not concluded, then we'll adjourn to another date. Adverse notices have been served. We have had some responses already. And so they'll be coming in any event. Individuals will be coming to cross-examine and present their position and to cross-examine. So we'll take it from there. But you'll be given good time, adequate notice when we will be resuming after today.
Thank you.
Council?
Thank you, Madam Chair. Good morning, Mr. Brown. Good morning, Mr. Brown. Yesterday, we had concluded after you had read an exhibit specifically had been a statement by one John Emmanuel Augustus, which had been given to the police. I wish to direct your attention to a statement of Algernon Conway Doers.
Yes.
D-O-E-R-S.
Yes.
That statement, it forms part of your package.
It does as an attachment to the police report.
And you had submitted a copy of that statement to the Secretariat of the Inquiry, and you wish to place reliance on it?
Yes, on both.
And that statement is dated the 26th day of November, 1975.
That's correct.
It's signed by Algernon Doers, D-O-E-R-S, Algernon, D-O-E-R-S.
Correct.
And the signature was witnessed by T. Cassin, C-A-S-S-I-N, DS-55. Is that correct?
That is correct.
Permission, Madam Chair, to tender and admit the statement referred to as Exhibit CNLB 15.
Yes?
Thank you. May the witness be permitted to read the statement?
Yes, yes, sir.
Thank you, Chair. A statement of witness. Statement of Algernon Conway Doers. Occupation, taxi operator. Address, Church Hill, Somerset. Phone number 41179. This statement is true to the best of my knowledge and belief, and I make it known that if it is tendered in evidence, I shall be liable to prosecution if I have willfully stated in it anything which I know to be false or do not believe to be true, dated 26th of November, 1975. I am a taxi driver and I live at the above address. I am divorced. I remember that some time ago, I was driving in my taxi when I had an occasion to sign a document for Mr. Russell Perrin. I knew Mr. Perrin as I used to drive him many times. On this one occasion, I picked up Mr. Perrin somewhere in town. I can't say where. It was in the morning, and I drove him to the rear of Government Gate. That's to the left of St. Monica's Mission. He told me to stop nearby a man standing on the bank looking towards the North Shore. Mr. Perman ran over to this man, and I saw him showing this man a piece of paper. This man is named Smith. I think it's Howard Smith. Mr. Perman then came back to the taxi with this paper he had shown Smith, and the paper was folded over a couple of times. Mr. Perman asked me to sign the paper as a witness, and I did. I saw no names or writing on this paper. I knew Mr. Perman was in real estate, and I figured he was doing a deal with Mr. Smith, and he wanted me to be their witness to it. Mr. Perman then went back to Mr. Smith, showed him the paper as if to say, "Is that all right?" Then he came back to the taxi and told me to drive him to town. He had this piece of paper with him when he came back to the taxi. I took him back to town, and I can't say where I dropped him off to. I definitely only signed my signature once, and that's the only time I have ever signed my name for Mr. Perman. I have never had any dealings with Mr. Perman except drive him in my taxi, and I was paid nothing for my signature. I have been shown a copy of a sales agreement by Detective Sergeant Casson. My signature is on that agreement. I have been told by Detective Sergeant Casson that he had 2 agreements with my signatures in both, and both signatures are originals. That cannot be right. I only signed one form. I only signed my signature once. I'm sure about this. I now think that the paper I signed was bigger than the one shown to me by Sergeant Casson. I really cannot be definite on this point. I am definite I only gave one signature, and the one I've been shown looks like mine. If there is 2 signatures, then one of them was made by someone else. Elgin endorsed, statement recorded at dictation of Doers, and on completion, it was read to him. He read it and signed same. Thomas Casson, Detective Sergeant 55. That concludes the statement, Counsel.
Thank you very much. Now, you had also shared with us a copy of what purports to be a statement, a report, what purports to be a report from Detective Sergeant Cassin. You had also shared that document with us?
Yes.
And that document refers specifically to a complaint received from Mrs. Barbara Lucille Brown of Spanish Point, Pembroke West. Sir?
Yes, that is correct.
And that document you had shared with us, along with the other 2 that you have just read, CNLB 15 and CNLB 14.
Yes.
And you shared it with us.
That's correct.
All 3 in proof of your claim. Correct?
That's correct.
Madam Chair, the document which is marked Exhibit E when it was sent to us, it has at its face the words "to the Commissioner of Police." Superintendent C, C is in inverted commas. Division Major Incident Room. From Thomas Cassin, DS 55. date 7th February 1976. Subject complaint relating to estate.
Complaint related to
Estate of John Augustus Virgil, relating to estate of John Augustus Virgil. My application that document be tendered and admitted as exhibit CNLB 16.
is so entered as CNLB 16. Help me, please, counsel, because I'd like to make sure that I have the first bit correct. You say that it's sent to the Commissioner of Police, Superintendent.
C is in inverted commas. Division Major Incident Room.
Major Incident Room.
From Thomas
Cassin, DS 55?
Yes, madam.
Okay. And it's dated then February 1976.
No, madam. 7th of February, 1976.
7th Feb 1976. Okay. And it's a complaint related to the estate of John Augustus Virgil.
That's correct, madam.
And I've entered it as exhibit CNLB 16.
Thank you very much.
Thank you.
I'd ask that the witness to be permitted to read
Certainly,
document which comprises 4 pages.
certainly. Yes?
Please go ahead.
Yes, thank you. To the Commissioner of Police, Superintendent C, Division Major Incident Room, from Thomas Cassin, DS 55, date 7th of February, 1976. Subject, complaint relating to estate of John Augustus Virgil. Complainant, Mrs. Barbara Lucille Brown, Spanish Point, Pembroke West, telephone 20286. Complaint. She is one of the beneficiaries of her uncle's will, namely one John Augustus Alexander Virgil, who passed away on the 17th of January, 1972. She alleges irregularities in the purchase of land from Virgil by one Russell Levi Perriman in 1969. Further, with respect to the complaint, that Virgil didn't know what he was doing, as he was a sick man and also an alcoholic. That a witness to the sales agreement between Virgil and Perriman and Mr. Algin Endures gave his signature on the street to Perriman, and Virgil was not present. Documents received from complainant. TC1. Last will and testament of John Augustus Alexander Virgil, made on the 21st of May, 1964, in the presence of Robert Murdia of Appleby, Sperling, and Kemp. TC2, carbon copy of sales agreement dated 11th of January, 1969, between Virgil and Perriman for sale of land earned by Virgil for £7,000 Witness to agreement, Algin and Dewars. Signatures of Virgil, Perriman, and Dewars are original on this document. Documents received from Mr. Michael Mello, representing Mrs. Brown. TC3, copy of indenture dated 15th of April, 1969, resale of land in Sands Parish to Russell Levi Perriman from John Augustus Alexander Virgil for £7,000. Indenture drawn up by David Wilkinson of the firm Cox and Wilkinson. Copy of indenture dated 4th of November, 1970, which relates to an indenture dated 15th of April, 1969, for sale of land from Russell Levi Perriman to one John Emmanuel Augustus. Copy of letter sent to Sands Parish Vestry dated 15th of April, 1969 by the office of David Wilkinson, notifying change of ownership of land from Perryman to Augustus. TC6, copy sketch of Virgil land in Sands Parish. TC7, copy letter dated 19th of February, 1969 from Robert Modia to David Wilkinson relating to instructions received by Modia from Virgil. Copy receipt for deeds to Virgil, property attached. TC8, copy receipt dated 10th December 1970 relating to documents received by J.W. Swan Limited from Peter Smith Barristers. The following documents are listed as having been received by J.W. Swan Limited. Indenture dated 15th of April 1969, sale of land from Virgil to Perryman. Indenture dated 15th of April 1969, sale of land from Perryman to Augustus. On the 25th November 1975, I saw Robert Modia at his office. He stated that Mr. Virgil came to see him on the 19th of February 1969. Virgil showed him a sales agreement for sale of his land to Russell Levi Perryman. Mr. Virgil instructed Mr. R. Modia, to send the deeds of the land to David Wilkinson, who was representing Perryman. This Modia did. There is no doubt in Modia's mind that the man who gave him these instructions was John Virgil. He saw Virgil prior to this date and drew up Virgil's will in 1964. Mr. Modia still had in his possession too. TC9, sales agreement dated 11th of January 1969. This was the original agreement. Agreement had original signatures by Perryman, Virgil, and witness doers. I obtained this document on receipt. TC10, on 26th of November 1975, I saw Algernon Dewars. I recorded a statement from Dewars and obtained samples of his handwriting. Dewars stated that he gave one signature to Russell Perryman in a taxi up a government gate, Pembroke, one morning in 1969. He is sure he only gave one signature. On the 15th of December, 1975, I saw one John Emmanuel Augustus. He could only say that he did buy land in Sands Parish from Russell Levi Perryman in 1969 for 18,000 pounds sterling. The transaction was handled by Wilkinson's office. Property was later sold to J.W. Swan in 1970 for 60,000 pounds sterling. An elderly man whose memory is not good. That's in brackets. TC12, on the 8th of December, 1975, I saw Michael Collier, Bank of Butterfield, received a copy of fixed deposit account of John Augustus Virgil. Also received original savings account signatures of Virgil. On the 29th of January, 1976, Detective Inspector Waddle did a preliminary examination of signature of Virgil and Dewars on sales agreement against samples. His opinion is that Dewars' signature on the sales agreement are not similar. The signatures of John Virgil on the sales agreement are similar. He suggests a proper examination by an expert should be done if the case warrants such action. It cannot be done in Bermuda. On the 28th of January, 1976, I saw David Wilkinson at his office at Sophia House at Sophia Church Street. I explained the nature of my inquiries and asked if he had any original documents relating to the transactions between Perryman, Virgil, and Perryman and Augustus. He stated he would not keep original documents as they would stay with the papers to the property. I then saw a sales agreement dated 19th of February, 1969 in the file he had. I asked him if he had the sales agreement for transaction between Perriman and Augustus. He answered yes. I asked for the document for examination. He refused. I asked for a copy. He refused. I asked him the date of the agreement. He took some time to answer, and I said, would it be the 19th of February, 1969? He said, yes. Mr. Wilkinson admitted that he had drawn up the conveyance for sale of property from Virgil to Perriman on the 15th of April, 1969, and also drew up a conveyance between Perriman and Augustus on the same date, 15th of April, 1969. I asked him if he didn't think it was odd that Perriman should agree to sell the Virgil property on the 19th of February, 1969 for 18,000 pounds before he actually bought the property. A copy of this conveyance in possession of the police has no signatures thereon. Mr. Wilkinson did not know John Virgil prior to 15th of April, 1969. Again, on the 15th of April, 1969, another conveyance was drawn up by David Wilkinson for actual sale of land from Perriman to a Mr. John Augustus for 18,000 pounds. The original conveyance has not been found to date, and no copies have been found. However, both of these conveyances are in existence as they have been sent to J.W. Swan Limited by Peter Smith's office, CTC 8. Also mention of the second conveyance between Perriman and Augustus is mentioned in TC 4. Again, on the 15th of April, David Wilkinson's office sent letter, TC 5, to Sands Parish Vestry notifying changes of ownership of land from Perriman to John Augustus. Statement of complaint, Barbara Brown, TC 14. She gives background re-Algernon doors and also states that Mr. David Wilkinson informed her by telephone that Perriman had bought land from her uncle and that he, Wilkinson, had handled the transaction and that Perriman was a crook. Wilkinson also told her this on a second occasion, namely that Perriman was a crook. A most unusual comment from the lawyer dealing with the transactions relating to Virgil's property, and a different story than he gave to police. Conveyance dated 15th of April, 1969, TC3, shows that Virgil received 7,000 pounds on that date. Mr. Wilkinson stated that a check was made out to Virgil on that date for a sum of just over 6,800 pounds. Copy of fixed deposit account of John Augustus Alexander Virgil for Bank of Butterfield shows 6,800 pounds deposited to Virgil's account on 4th of July, 1969. The bank cannot find record of check. Mr. Wilkinson should have a check and stated that he could find it. Conclusion. It is possible that John Virgil never signed a conveyance dated 15th of April, 1969 at David Wilkinson's office. He was not known to Wilkinson, and indeed Perriman could have bought someone else also instead. Without the original conveyance and examination of Virgil's signature on that document, nothing further can be done. At present, Mr. John W. Swan has started a search for this document without success to date. I'm of the opinion that a civil suit could be instituted against Russell Levi Perriman for failing to make full of value to Virgil land, to enter into a sales agreement for 7,000 pounds sterling. On 11th of January, 1969, without a witness being present to the transaction, and then agreeing to sell that land to another party, John Augustus, on 19th of February 1969 for 18,000 pounds sterling, only after deeds to Virgil's property were sent to Perriman's lawyer on 19th of February 1969, makes me think that agreement between Augustus and Perriman for sale of the land was made before the 19th of February, the date of the sales agreement. It should also be noted that when Perriman agreed to sell the land to Augustus, he had only paid Virgil a deposit of 100 pounds on 11th of January 1969. Further, the full sale of the land from Virgil to Perriman was not completed until 15th of April 1969, when 7,000 pounds sterling was paid to Virgil. And on the same day, the full sale of the land by Perriman to Augustus was completed for 18,000 pounds sterling. As the search for the conveyance of April 15, 1969 has been underway for about 5 months without success to date, I would suggest that a copy of this report, also the documents, be sent to Mr. Michael Mello, care of Peter Smith Barristers, Hamilton, for his perusal and civil action if necessary. Thomas Casson, DS55. On 15th of April 1969, for 7,000 pounds, Mr. Wilkinson didn't think it was odd at all because Perriman had a lawful contract with Virgil, namely the sales agreement dated 11th of January 1969. I asked him his view of Perriman buying the property on the 15th of April 1969 for 7,000 pounds and selling it the same day to Augustus for 18,000 pounds. He stated there was nothing wrong with that. TC 13. Mr. Wilkinson gave me a copy of a letter received from Appleby, Sperling, and Kemp dated 19th of February 1969. This letter is the same as letter TC 7. Mr. Wilkinson finally that the document sales agreement dated 19th of February 1969 was the property of his client, Mr. Perriman, and at my suggestion, he said he would speak with Perriman about this document. Mr. Wilkinson did not know Virgil prior to 15th of April, 1969. On the 2nd of February, 1976, I saw Russell Levi Perriman. I told him of the allegations made by a complainant and referred to the documents held by his lawyer, Mr. Wilkinson. Mr. Perriman stated that there was nothing wrong with the buying of the property, and he had no objections to the police examining any documents held by his lawyer. He stated he would call Mr. Wilkinson and so instruct him. He was very cooperative. On the 9th of February, 1976, I spoke to Mr. Wilkinson on telephone. He agreed that Mr. Perriman had told him to let police have anything they wanted. He then started to berate me for doing this inquiry. In his words, I was wasting thousands of dollars of taxpayers' money for no reason whatsoever. There was nothing wrong to investigate it, and it ought to be stopped. He further stated that he had done some background on this case and remembered a woman who worked as a waitress at the Hog Penny had come to him and told him that Virgil was being robbed of his property, and he made sure that he wasn't. Regardless of what his client had said, Mr. Wilkinson refused to give or allow me to examine the sales agreement dated 19th of February, 1969. A search has been in progress for a number of months for the conveyance dated 15th of April, 1969 by J.W. Swan Limited, without success to date. Copy of one of the conveyances, TC3, between Virgil and Perriman has no signature thereon. Summary. John Augustus Alexander Virgil apparently agreed to sell his property, land, in Sands Parish to Russell Levi Perriman for 7,000 pounds. and a sales agreement was drawn up dated 11th of January 1969. Agreement was signed by Russell Levi Perriman and a witness, Algernon Dewis. A 100 pounds deposit was allegedly paid to Virgil. The carbon copy of sales agreement was found in Virgil's possession after he died. This carbon copy had original signatures thereon. On the 19th of February, 1969, John Virgil took the original sales agreement to his lawyer, Robert Modia, and on Virgil's instructions, Modia sent the deeds of the land to Mr. Wilkinson representing Russell Perriman. This original sales agreement also had original Russell Levi Perriman, John Virgil, and witness. Virgil had both original and carbon copy in his possession. Dewar states that he only gave one signature and it was given to Perriman in a taxi. Dewar's witnessed nothing. PI examination of Dewar's signature on agreement against samples from Dewar's show they don't match. On the 19th of February, 1969, same date, Russell Perriman agreed to sell the land to one John Augustus for 18,000 pounds. A sales agreement was drawn up between these two men, and this agreement is in the hands of David Wilkinson. On the 15th of April, 1969, a conveyance was drawn up for actual sale to Virgil's land to Russell Perriman for 7,000 pounds by Wilkinson. This original conveyance has not been found to date. Received from Detective Sergeant Casson, documents related to the estate of John Alexander Augustus Virgil.
This document is not signed. There's no signature that appears on this document.
I don't see one.
Okay. And for the other statements, Dewar and Augustus,
Yes,
there are no signatures appearing there.
that is correct.
Okay. Now, in 1982, the beneficiaries had taken to court some persons whom you have named here today and whom adverse notices have been sent to. And in respect of that matter, the presiding judge had indicated that the beneficiaries matter, who are the plaintiff, amount to a fishing for information to see if there is any wrongdoing, and the application of the plaintiff was refused. You're familiar with that matter brought by Lucille Brown, Sylvia Davis, Marion Johnson, Eunice Ming, Gladwin Ming, Glenn Ming, Marie Diane Spence, claiming as beneficiaries under the last will and testament of John Augustus Alexander Virgil deceased. You're aware of that matter?
I am.
And also in 1998, the devisees of the estate of the late John Augustus Alexander Virgil, who were plaintiffs, had brought a matter in the Supreme Court of Bermuda civil jurisdiction against John William David Swan. It was an application by the plaintiffs for discovery prior to the commencement of proceedings. And the court then had issued a judgment had issued a judgment refusing the application for discovery that the plaintiff's application amounts to I'm sorry, I think the page just got a little confused. I'm going to start again, Madam Chair. In respect to the first matter of the parties Barbara Lucille Brown, Sylvia Davis, Marion Johnson, Eunice Ming, Gladwin Ming, Glenn Ming, and Marie Diane Spence. This matter was against the Bank of Butterfield and Son, John Swan Limited, Bermuda Housing Corporation, John Alfred Virgil, Rhoda Uriel Tavares, Irville Erskine Ingram, Owen Lloyd Thompson, Laura Patricia Thompson, and Robert Keith Horton. In respect of that matter, the court, Justice Martin Ward, the judgment was accordingly, it follows in my opinion, such issues should be canvassed, if at all, by way of writ and not by way of originating summons. This course would provide proposed defendants with all the machinery available for discovering what precisely the case alleged against them is. And the matter had been dismissed. You recall that?
I do.
Okay, just wait, I'm coming. Just wait. Sorry. It's Civil Jurisdiction 1982, number 252. Civil Jurisdiction 1982, number 252. Judgment of Justice Martin Ward. And also, sir, in respect of the Supreme Court of Bermuda Civil Jurisdiction 1998, number 60, between the devisees of the estate of the late John Augustus Alexander Virgil and John William David Swan, before it was an application by the plaintiff, the devisees of the estate, for discovery prior to the commencement of proceedings, which may or may not happen in relation to the defendant. There, Mr. Justice Vincent Marbua, the pronunciation, thank you very much, had issued judgment, Mr. Brown, that in my view, the plaintiff's application amounts to a fishing for information to see if there's any wrongdoing. And the judgment is there. That judgment is 1998, number 60, Civil Jurisdiction, 1998, number 60. Now, Mr. Brown, you have come here over the last few days giving evidence. What is different today? In respect, these two matters were dismissed from the court. You were before the court, they were dismissed. I've given the reasons. You are now here making a claim. What is different in respect of your presentation before the commission?
The major difference is that we are now examining the fraud that was surround the two transactions, one in 61-2 and the other in 68-69. We're of the view that the previous applications for justice were not as they were not structured as they should have been. And so we are now here advancing the case for fraudulent misbehavior on behalf of the parties we've spoken about earlier, and presenting our evidence accordingly. But my brother would like to add a bit on with respect to a response to that question, if that's okay.
Okay, and just to remember, we're not, the question is not specific to the court matters. We're not going to look at the merit of the court matters.
Yes.
The specific question is in relation to what is different today in terms of what you're presenting as against what you presented then. And those matters were, one was struck out and the other one indicated that the application for discovery would not have been permitted.
Good morning.
Sure. Morning, sir.
Well, it is our understanding to the 1984 court date, the reason it was struck out.
But remember, sir, I don't want to talk, remember, we don't want to revisit the court matter. I'm just
Nope.
asking you, just listen carefully
Okay.
and think about the answer. What is different in terms of what you're presenting today over the last few days as against what previously had been presented?
Just to echo my brother, it's fraud because back then we were going under a civil matter, and they cited the statute of limitations on two instances, and the first instance they cited no cause of action.
Okay. And the evidence that you place reliance then, is it the same evidence that you're placing reliance now or different evidence?
The same and some.
Sorry.
The same and many more evidence.
Okay, okay. Same and many more, that's okay.
Yeah, you
Yes.
did.
We have what we've presented with A to N and then the 18 in
Yes.
terms of evidence. That scope of evidence was not used in previous matters.
Okay, okay. Thank you. Thank you very much. And just to repeat what you said, the exhibits A through to N that you have placed reliance here, and the exhibits 1 through to 18 that you have placed reliance on also, you had not previously relied on those in the two court matters?
We would have relied on some of that content, but importantly, the relationship with some of the dates and documents was not presented. And we give examples of that if you'd like, but that level of due diligence, I carefully suggest, was absent at the time.
Okay. And at the time, because the matters, as I indicated, were the matters in 1982, also the matter in 1998. In respect of for instance, the title deeds, did you place reliance on them then? The title deeds that you presented yesterday,
Yes.
was reliance placed on them at any time during these cases?
I am not sure. I would have to defer.
Okay.
Just so that the record is correct.
Okay. Well, not sure is fine, but you can seek counsel in that regard to find out.
Okay.
Okay. Madam Chair, at this time, I have no further questions.
I think, or perhaps you could guide me, counsel, whether commissioners would be given an opportunity to ask questions at this stage, because is there evidence closed?
Well, it is not closed, would not be closed because we have,
Of the adverse notices?
and if need arises, I would re-examine if the need arises, the witnesses in that regard. So at this time, and in light of the fact that the commissioners may have questions, I propose that we could adjourn at this stage.
Right.
It's a convenient point for us to do so. And then we'll advise the parties of the date when we resume in that regard.
Right, so commissioners, I'm not going to be asked, you will not be allowed to ask questions at this stage. Upon resumption, once we have further evidence, then you'll be able to ask questions then. Is that correct, counsel?
It is, Madam Chair.
Okay. So, Mr. Brown, We are adjourning at this point in time. Those are the questions that council have for you. And what we propose to do, we have served adverse notices. We have had some response, and adverse notice means people, the individuals upon whom the notices have been served will be given an opportunity to come in and ask questions. And so once we have resolved that, then you'll be notified when we wish you to return. Correct, counsel?
Okay, that's fine. Thank you.
Sorry, do you wish to say something?
No, I was just acknowledging your.
Thank you. Thank you. All right, and so we will adjourn for now, council. We'll take the luncheon break now.
Thank you.
And then I do not believe, it's now what, 1 o'clock?
1 o'clock.
1 o'clock. I do not believe we'll be convening this afternoon.
Very well, madam.
So my technicians, this is it for